Magandang umaga mga kasama, especially sa aking mga estudyante sa Tarlac State University, sa mga third year students na hawak ko dito sa subject na non-institutional correction or correctional administration too. Today I will give you some introduction and some history of our subject so that ang bawat isa sa inyo ay magkaroon ng konting idea patungkol sa ating subject. Okay? So, this course will be focusing on probation. Sa Pilipinas, ang ating probation law is Presidential Decree 968, wherein ang focus is to impose on convicted offenders a sentence that allows them to remain in the community. So yan yung isa sa mga programa ngayon ng gobyerno na kung saan ay hindi mo na kailangang ikulong ang tao if he or she is capable or qualified to avail this program, ay binibigyan sila ng pagkakataon. But always remember, probation is not a right, it is a discretion. It is a privilege and discretion of the judge. Always remember that. So, kung hindi yan rights, so ibig sabihin, hindi mo pwedeng i-demand ang government na bigyan ka ng programang ito. Whether you are qualified, you cannot demand it to the government. It is a privilege given to offenders para mabigyan sila ng pagkakataon na ma-reform sa pamamagitan ng individualized treatment. And here, in non-institutional correction, they were given the chance to go back to the community, to stay in their family, and of course to serve in the community while rendering their sentence in the community. So ganyan po ang non-institutional correction. And of course, pagka ikaw ay nandito sa programa ng non-institutional correction or program, ay ikaw ay hindi talaga malaya. There are certain conditions that you need to follow. And merong probation officer that will supervise you during your program. So, ibig sabihin, hindi mo pwedeng gawin kung ano ang gusto mo na sa tingin mo ay meron ka ng freedom to do that. No. There are certain conditions that you need to follow. And there are probation officers that will supervise and monitor you day to day until such time na ikaw ay matapos sa iyong programa. So ganyan po ang non-institutional correction. Now, the term probation came from the Latin term probare, which means to prove. Because probation is a conditional release into the community. It is a conditional release. And then ang sabi dito, the probation period is a time of testing. Testing means that titignan nila kung ikaw ay mapagkakatiwalaan, kung ikaw ay susunod sa mga condition, kung ikaw ay magbabiolate sa mga policies, at kung ikaw ay makikipag-cooperate sa iyong rehabilitation program. So it is a time of testing. And they will test your character, they will test your ability to meet certain requirements. So yan po yung probation. Yan po yung iba pang mga community-based program natin concerning the rehabilitation of the offender. Another is, convicted persons must prove to the court that they are capable of remaining in the community. Supposed to be nakakulong sila eh. But because of the privilege that were given to them, ay oobserbahan sila kung sila ba ay capable or sila ba ay dapat mag-stay or nagiging threat sila, nagiging problema sila sa community habang sila ay nagre-render ng service sa kanilang program. So yan yung mga bagay na titignan kapag ka ang isang tao, kapag ka ang isang convicted offender ay nabigyan ng pagkakataon na sumailalim sa probation program. Now, in our subject, we will discuss comprehensively the Presidential Decree 968 or the Probation Law of 1976. At mayroong bagong batas, later on we will discuss that, na nag-amend ng some provisions of Presidential Decree 968. Another is the concept, history, and principles of probation, investigation, selection, process, and conditions of probation. Another discussion will be on the different forms of executive clemency under Republic Act 4103 and under the executive clemency of the President. So yan yung mga bagay na magiging focus natin at magiging sentro ng ating pag-aaral dito sa non-institutional correction. Now, in the criminology parlance, some overview of this subject. The word correction may be understood as the fourth pillar of criminal justice system. Hindi na iba sa atin to. In the Philippines, we have 5 pillars of criminal justice system. One is law enforcement, and then second is prosecution, third is court, and fourth is correction pillar, and the fifth one is the community. So, non-institutional correction is under the pillar of correction, okay, which is charged with reforming and rehabilitating offenders. So, the act of reforming offenders by means of institution is known as correctional institution. In the old laws of criminology, old memorandums of CHED, ang correction area of criminology was only divided into 2 subjects, and that is institutional correction and of course the non-institutional correction. But in the new CHED memorandum, in the new law of criminology, ay nadagdagan ang mga subjects sa correctional administration at nadagdag doon ang therapeutic modality. So, yung second subject is the non-institutional correction, wherein the focus is more on reforming offenders by other means outside institution. Institutional correction is more on incarceration of offenders in prison or jail. Non-institutional correction is more on reformation outside jail or prison. Death penalty was, however, proved to be useless in decreasing crime rate. So as a move by the Congress was made to abolish it. Before ay meron tayong death penalty at nakita ng mga mambabatas na hindi effective ang death penalty that time. While because according to their study, na instead na mabawasan ang krimen, instead na mabawasan ang rape cases, ang drug cases, and other heinous crimes, ay nadadagdagan pa ito at nadadagdagan at para bang nagiging aggressive ang mga tao na gumawa pa ng mga ganitong krimen. So ano ang naging move ng ating mambabatas? So pinag-aralan nila yung kanilang records at nagkaroon ng proposal, isang bill to abolish the existing law of death penalty. At nagkaroon ng votation, and as per record, by a vote of 119 to 20, the House of Representatives approved on a third and final reading on June 6, 2006, the measure abolishing the death penalty in the country. So na-abolish yan, of course, sa Senate. Nagkaroon din sila ng hearing and majority of them agreed to the House of Representatives, to the Congress, na i-abolish ang death penalty. So ito ang mga reasons na nakita kung bakit kailangan i-abolish ang death penalty. Number one, according to them, death penalty is retributive. Ibig sabihin, it is intended only for them to revenge doon sa culprit, sa offender. And it is the ultimate cruel and inhumane punishment. Hindi daw makatao. Especially the Philippines was known to be a major belief in Christianity. We are known being a Christian country. So, killing is not a language of a Christian country. According to them, it is inhumane, it is ultimate cruel, so there is a need to abolish death penalty. Sabi nila. Third, it is irrevocable. Hindi daw ito parang kanin na isinubo mo at pwede mong iluwa, ibalik, or candy na pagkaayaw mo ay pwede mong ibalik. No, ang buhay daw ng tao ay isa lang. It is irrevocable. So once na yan ay namatay, you cannot bring back yung kanyang buhay. So kailangan ma-abolish ang death penalty. It shuts out rehabilitative justice. Wala nang chance na magbago ang offender. Kasi patay na eh. But kung yan ay ikukulong mo at mag-stay siya sa kulungan for a longer years, so there is a chance para sa kanya na magbago. Yun yung sinasabi nila. It raises the likelihood of criminals becoming more violent for fear of being convicted by death sentence. So magiging aggressive sila. And then number 6, it is anti-poor. Why? Because alam naman natin na mas malaki ang pag-asa kung na ma-acquit o ma-dismiss ang kaso kung ang abogado na humahawak sa iyo ay magaling at may influence. And of course, kung yan ay may influence at yan ay magaling, kilala sa society, mas mahal ang bayad at mas malaki ang kanilang professional fee. While kung ikaw ay mahirap, you cannot afford to avail that services dahil nga wala kang pambayad. So it is anti-poor. So in the abolition of death penalty, non-institutional correction was strengthened. So dyan na nag-focus ang ating government, and even sa institutional correction, the main focus of institutional correction is more on rehabilitation program, reformation, and transformation of an inmate. So ganun din dito. In the abolition of death penalty, non-institutional correction was strengthened. And the main concentration of the non-institutional treatment includes probation, parole, we will discuss that later on, good conduct time allowance, the old and the new laws, and reprieve, suspension of sentence, and even amnesty. We will discuss that sa ating subject dito sa non-institutional correction. So there are significant personalities, events, and places in relation to probation in the international setting. So ito ay konting history lamang, balikan lang natin kung saan ba nag-originate ang probation at kung paano siya nagsimula. Now, number one, we have the laws of Babylon, Greece, and Rome. So these laws introduce the principle of an eye for an eye and the tooth for a tooth principle. It is known as the principle of lex talionis, or the law of retribution, or the law of retaliation. Noong una, ang description ng lex talionis ay maganda. Why? Ang sabi dito, the purpose of this law or of this principle is to provide equitable retribution for an offended party. Meaning, kung ano ang ginawa ng offenders sa offended party, ay ang principle dito kailangan ay equal doon sa magiging punishment. Hindi pwedeng tumaas, hindi pwedeng bumaba. It must always be equal on the gravity of the offense. So kaya po ang sabi dito, the purpose of the law is to provide equitable retribution of an offended party. So a person who has injured another person receives the same injury in compensation. That is the principle of lex talionis, or the so-called the law of retaliation. But later on, this principle became barbaric and vengeful to the point na sobra-sobra ang ginagawa nilang punishment just for them na makaganti doon sa offender. So that is number one. Number two, during early 19th century in England, English magistrates initiated experiments to determine the possibility of reformation of some young and experienced offenders from the stigma of prison. So, dati kasi magkasama, kung ikaw ay youth, kabataan mo, or sa mga adult, yung mga matatanda, ay magkakasama yan sa prison. So, nagkaroon ng experiment. Why not? Ang sabi nila, ilabas natin ang mga youth, expose them again to community, at tignan natin kung mas mabilis ang kanilang reformation na wala dito sa prison at sila ay nabibigyan ng pagkakataong maki-interact at ma-expose muli sa community. But, ang sabi ganon, youthful offenders would be brought back for sentence if the condition of release would be violated. So that is the principle of probation. Kasi ganun din sa atin. Ikaw ay hindi kukulong if you are qualified. Ilalabas ka, babalik ka sa community. But if you violated the law, violated the condition of probation, you will be brought back for the sentence at ikaw ay babalik sa prison. So ganyan, kapareho yung idea ng probation natin ngayon dito sa experiment na ginawa nila during the early 19th century in England. Now, Matthew Davenport Hill, he is considered as the father of probation in England. He introduced the following beliefs in relation to offenders. Ito yun. Ito ang kanyang idea patungkol dito. Number one, individuals are not fully corrupt. Ibig sabihin, meron at merong chance na siya ay makarecover, meron at merong chance na siya ay ma-reform or ma-rehabilitate. Ibig sabihin, ang tao ay hindi siya talaga masama, kundi siya ay merong pagkakataon na magbago. There is a reasonable hope of reformation of offenders, and if adults were given the chance as guardians of young convicts, they will be kind enough to take charge of the latter. So yan po si Matthew Davenport Hill, so that sa kanyang principle, he was considered in England as the father of probation. So kinilala ang kanyang principle, kinilala ang kanyang belief, at ibinigay sa kanya ang pagiging tatay ng probation dito sa England. Another, we have John Augustus. John Augustus was considered as the first official probation officer. He was also known later as the father of probation in the USA, in America. And marami rin nagsasabi that because of his contribution in probation, ay siya ang kinukonsider bilang world father of probation. This is because of his pioneering efforts to campaign for more lenient sentences for convicted criminals based on their background. And because of that, Augustus' efforts are credited with establishment of the pre-sentence investigation. Pre-sentence investigation, or PSI, is one of the requirement ng ating batas bago mag-decide ang judge kung siya ba ay bibigyan or papaboran sa kanyang request na maka-avail ng probation program. So PSI, ginagawa ito before the judge will decide at maglabas ng resolution if the petition was, kung ang petition will be given to him na merong na favorable sa kanya. Okay? Next, Edward Savage. Edward Savage, he was a Boston police captain who became America's first paid probation officer in 1878. Okay? Number 6, Gardner Taft. He was a director of the Massachusetts Board of State Charity, and he reported the result of probation in cases of juvenile offenders. Juvenile offenders, ito yung mga kabataan na nagkasala sa batas or morally speaking ay they are delinquent at sila ay merong violation sa mga policies ng government. So, he reported the results of probation in cases of juvenile offenders to the legislature, so the latter authorized the city of Boston to appoint probation officer for adult offenders. So nakita natin yung mga development from history at hanggang ngayon ay pilit na dinidevelop ang programang ito to cater more offenders at pinag-aaralan na kung paano pa ang mas effective way kung paano i-implement ang probation system natin. Now, in Massachusetts became the first state to enact a probation law. That is on April 21, 1878, under the administration of Governor Alexander H. Rice. Said governor appointed and prescribed duties for paid probation officers. The first state to enact probation law. Secondly, Vermont. Vermont was the second state to enact a general probation law. It was the first to adopt a county, not a country. County means village, where each county court was required to appoint a probation officer whose duty was to investigate the accused, give recommendation that such person, if convicted, be placed on probation. Okay? Next. Number 9, we have Rhode Island, the third state to have a general type of probation law, and it was known as the Act of 1899. This law empowered the Board of State Charities of the Rhode Island to appoint a state probation officer and additional probation officers, one of whom shall be a woman. So yan yung kanilang batas. March 4, 1925, the United States had the first Federal Probation Act when President Calvin Coolidge signed it into law. Makita ninyo na meron na itong mga state, but yung buong Amerika as one law, wala pa. That's why on 1925, through President Calvin Coolidge, ay nagkaroon ng federal law concerning probation ang buong United States of America. So this probation law had its roots in the practice of judicial reprieve, which was used in English courts to serve as a temporary suspension of sentence to allow a defendant to appeal to the Crown for a pardon. Act 4221, dito naman na yan sa Pilipinas, yan yung pinakaunang batas natin pagdating sa probation. And it was enacted on August 7, 1935. The first probation law in the Philippines. But unfortunately, in November 16, 1937, after 2 years, the Supreme Court declared Act 4221, our first probation law here in the Philippines. The Supreme Court declared it unconstitutional. At ang sabi ng Supreme Court, it encroaches the legislative power of the government. At meron pang mga reasons, and we will discuss that later on. Some reasons why the Supreme Court, under the case of the people of the Philippines versus Vera, why the Supreme Court of the Philippines declared Act 4221 unconstitutional. Okay? And then after that, for how many years ay walang lumabas na batas ang Pilipinas concerning sa probation. And from 1937 to 1976 officially ay nagkaroon po tayo ng probation law, at yan ang existing law natin ngayon na mas kilala bilang Adult Probation Law or the Presidential Decree 968. There are 3 theories of punishing criminals. Number 1, retribution. Retribution means punishment is imposed on the offender in order for the society to bend its anger toward and exact vengeance upon the criminal. Okay? So, the reason kung bakit pinarurusahan ng tao ay para makaganti. Dahil ang totoo niyan, kapag ang isang tao ay nakagawa ng violation o nakagawa ng krimen, ay hindi lamang sa biktima nagkasala itong offender nito. Pero ito ay nagkasala din sa lahat ng mga tao sa Pilipinas. Why? Dahil lahat tayo ay gumagawa parte at merong kinalaman sa paggawa ng mga batas dito po sa Pilipinas. Why? Through our representatives in the Congress, locally and nationally, nag-i-elect tayo ng ating mga congressman, congresswoman, mga mambabatas, and even sa Senate, ay sila yung ating mga representatives. At kung ano ang kanilang decision, pag napag-agrihan nila yon, it means ang majority o lahat tayo dito ay agree at tayo ay nag-decide, okay, sa paggawa ng batas na yun. So that's why, kung makikita nyo, pag may mga cases, criminal cases, ang palaging ano yan is people of the Philippines versus itong certain name o yung offender nito. Bakit? Ang kalaban na niya is no longer the victim, pero ang lahat ng mga tao sa Pilipinas. So part ng punishment, dahil ginawan tayo ng hindi maganda, gumawa siya ng krimen. So, one principle is retribution. The government is punishing them in order for the society to bend its anger and para magkaroon ng vengeance doon sa kriminal. It maintains that punishment is a device for ensuring that offenders pay for past misconduct. So that is one theory in punishing criminal. Second is deterrence. Deterrence is the punishment is imposed upon a person who has committed a crime. And there are two kinds of deterrence. One is the specific deterrence, wherein the punishment given to them or to the offender will dissuade the offender para sa kanya mismo, para siya ay matuto, para siya ay ma-realize niya ang kanyang kasalanan, at para pagdusahan niya yung kanyang pagkakamali. That is a specific deterrence. Nagbibigay ng punishment para parusahan or para mismo sa tao na gumawa ng krimen. Now, in the general deterrence or the second type of deterrence is para naman sa ibang tao. Okay? Ibig sabihin, nagbibigay ng punishment sa offender para makita ng tao, ng ibang tao, na kapag sila din ang gumawa ng krimen na yun, ay ganun din ang mangyayari. In other countries, andyan ang death by hanging in public, so that kapag nakita ng mga ibang tao na nakabigti ito, nakahang siya, at makikita ng tao, malalaman niya, ganitong krimen pala yan eh. So, ibig sabihin, yung makakakita sa punishment na yon ay matututo at siya mismo ay hindi nagagawa ng ganong krimen. Why? Kasi mangyayari at mangyayari sa kanya. So that is one principle ng general deterrence. It is for other persons. Yung specific, it is for the offender, para siya ay matuto at siya ay maparusahan. Okay? So deterrence, the punishment is imposed upon a person who has committed a crime for the learning of the offender and for the learning of other people. Now, thirdly, we have restraints. Restraints means if criminals are confined, yan yung ginagawa natin ngayon because we have no law on death penalty. So, ang pinaka-worst na punishment na may bibigay sa tao na nagkasala sa batas dito sa Pilipinas is imprisonment. So if criminals are confined, executed, or otherwise incapacitated because of imprisonment, such punishment will deny their ability or opportunity to commit further crimes that may harm other members of the society. Pag ikaw ay nakakulong, ay limited ang iyong freedom at ikaw ay restricted lamang sa limited area sa prison or sa jail. Okay, so that is restraint. But kung ating titignan, ang non-institutional correction is more on community-based approach. That's why hindi lahat ay qualified dito sa community-based program. Bakit? Kasi may mga tao na risky, may mga offenders na threats sa society, may mga tao na magbibigay, that is something na dangerous pag siya ay nasa community. Kaya hindi siya inaalaw sa non-institutional correction at intended siya for institutional correction, incarceration of offenders inside prison or jail. Now, another is, we have the forerunners of probation. Pag sinabi natin forerunners, ito yung pinanggalingan, origin, or naging basis. And number one is the benefits of the clergy. Ano itong benefits of the clergy? The earliest device for softening the brutal severity of punishment was the benefits of the clergy. Take note, ito daw ang isa sa paraan for softening, para gumaan-gaan yung severity of punishment na dapat i-impose doon sa offender. Bakit kaya? Ito ay nangyari during the time of Henry II in the 13th century, wherein the members of the clergy who were brought before the king's court may be claimed under the jurisdiction of the bishop or chaplain, requesting him on the grounds that he is subject to the ecclesiastical court only. So, may rights ang simbahan na kunin ang jurisdiction ng taong ito kung sa tingin niya ay, kung sa tingin ng church na yung violation or yung crime na ginawa ng tao ay pasok dito sa kanilang jurisdiction. Alam nyo, okay sana ito before, kaya lang nagkaroon ng corruption dito to the point na pag nakakumit ng krimen ng mga offender, ay pumupunta sila sa church at nagbabayad doon at yun ang magpo-force or ang gagawin ng church that time ay makikipag-negotiate sila sa king at para kunin ang kanilang ang jurisdiction ng kaso ng tao na nagbayad sa kanila. So nagkaroon ng corruption dito at hindi later on ay hindi naging effective dahil naging source, naging pinagmumulan ng corruption that time. Okay? And then we have the judicial reprieve. Judicial reprieve is a temporary withholding of sentence used by early English judges for the period of time whereby execution is suspended either before or after judgment. Okay? Sa Pilipinas, meron tayong reprieve, but it is only intended for death penalty. Kaya ang reprieve ngayon sa ating bansa ay hindi siya applicable. Okay? Dahil wala tayong death penalty. Pero dito ay meron silang tinatawag na judicial reprieve at yan ay ibinibigay either before or after judgment. Sa Pilipinas, after judgment kapag kaisasalang na sa death penalty. Okay? Ano ang mga reason or mga circumstances para ma-consider ang judicial reprieve? Judicial reprieve is temporary suspension, okay? At ito ang mga reason na pwedeng pumasok para i-consider ang judicial reprieve. Number one, not satisfied with the verdict, and the evidence is suspicious, and the indictment is insufficient. Kapag kakulang ang ebidensya or maliciously ay merong nangyaring decision na para bang hindi supported ng mga evidences at hindi naging satisfied doon sa decision, ay pwedeng mag-file ng judicial reprieve. There is a doubt whether the offense is within the clergy, the felony is light, and there are favorable circumstances appearing in the offender's criminal character. So yan yung mga circumstances wherein pwede silang mag-avail, pwede silang gumawa, at pwede silang mag-apply ng judicial reprieve. Okay? Next, we have recognizance. Recognizance, it also be considered as a direct ancestor of probation. Ano ang ibig sabihin? It originated from complying an obligation by making a promise. This is also one of the form of bail. Okay? At ang sabi niya, promise to comply with a court order even if the offender is not yet convicted but likely to be convicted. It included the promise to keep peace and be of good behavior. Okay, that is recognizance. Forerunners of probation, letter D, we have transportation or the so-called banishment. So the principal method of disposing offenders to other countries for the following purposes. Number one, to supply new colonies with cheap laborers. Ilalagay ka sa ibang area, magtatrabaho ka doon, work labor ka, at ikaw ay pakikinabangan ng gobyerno, at ang gobyerno nagbigay sa iyo doon, nagdala sa iyo, babayaran. To substitute brutal punishment at the homeland and to give offenders opportunity to be rehabilitated in a new country and to decongest the mainland. Para mabawasan, ibig sabihin, para instead na ikulong, bakit hindi na lang ilipat, i-transport sa ibang bansa na kung saan ay mas malaki ang chance na ikaw ay ma-rehabilitate. Now, what are the purpose of probation? Number one, to promote the correction and rehabilitation of an offender by providing him with individualized treatment. Ano pagkakaiba ng institutional and non-institutional? In institutional correction, you will be put to jail, to prison, at ang treatment doon is a mass treatment. Meaning, bahala kayo dyan, magsisi kayo, at maghihirap kayo dyan. But here, in probation, kapag ikaw ay nabigyan ng pagkakataon sa probation program, ay individualize ang treatment. Meaning, may magmomonitor sa iyo, may magsusupervise, bibigyan ka ng condition based on your background, based on your capability, and it's up to you na kasama mo ang family mo by your own, ay bibigyan kang chance na magbago, individualized treatment. To provide an opportunity for the reformation of a penitent offenders which might be less probable if he were to serve a prison sentence. Mas okay kung ikaw ay magre-render ng service outside prison. To prevent the commission of offenses. Bakit? Di ba, sir, dapat mas mapiprevent kapag ikaw ay nasa kulungan? Yes, pwede sa mga hard criminals, Pero sa mga first-time offenders, by accident, or sa mga uncontrollable circumstances at hindi naman talaga siya criminal, at siya ay maihihiwalay doon sa mga nakakulong sa kulungan at makakasama niya ang kanyang family, ay mas malaki ang chance na siya ay magbago. Okay? That's why one of the purpose of probation is to prevent the commission of offenses. Kapag kasama mo ang family mo, mas malaki ang chance na ikaw ay ma-rehabilitate. Okay? Next, characters of probation. It is more enlightened and humane. Enlightened because meron kang direction na sinusunod. Enlightened in a way na yung direction na yon ay ipinaparealize mo ang kahalagahan ng buhay. Enlightened in a means na ipinapakita mo na yung ginawa mo before ay pwede ka pang magbago through rehabilitation process, reformation process. And humane means makatao. Meaning, hindi mo siya dinideprive ng kanyang freedom, ng kanyang liberty, at binibigyan mong siya ng chance na hindi masira ang kanyang family. It aims to promote the reformation of the offenders. It reduces the incidence of recidivism. Pabalik-balik sa kulungan. Another, it is limited to offenders who are likely to respond favorably thereto. It extends to offenders individualized and community-based program. It is less costly on the part of the government, on the part of the family of the offender. It is less costly than the confinement of other offenders in prison. Okay? Benefits that may be obtained from probation are the following. Probation protects society, of course. Probation protects the victim. Another benefits, probation protects the family. Probation assists the government. It helps the offenders and justify the philosophy of men. Yan yung mga ilan sa mga beneficial effects ng probation sa isang offender na sumasa-ilalim sa probation program. So yan yung ating history, konting introduction, at next meeting we will discuss the law itself, Presidential Decree 968 and its amendment, and of course yung bagong batas na nag-amend ng certain provision ng Presidential Decree 968. So, thank you very much. Pag itong video na ito, yung discussion natin ngayong umaga, ay magsisilbing basis sa inyong quiz, sa inyong recitation, and of course, complement ng module na ibibigay namin sa inyo at ng iba pang mga discussion. Okay, thank you, and God bless, and good luck sa inyong pag-aaral. Thank you.